So welcome back after the work of the first panel. Let me introduce the second panel. The second panel will be the panel Whistleblowing Disinformation, Exploring the Legal Challenges. And I will give now the floor to the chair. The chair is Professor Maurizio Bianchini, who is an associate professor of business and law at the School of Law of the University of Padova. Maurizio, the floor is yours.
Thank you. Thank you, Costantino. Thank you, Costantino. Thanks to Costantino and to Stephen Olden for putting up together this excellent project and this outstanding group of panelists for this International Final Conference. I'm honored to be part of this project, and I'm very pleased to chair the second panel of day 2 of this great gathering together. Very interesting first panel. I hope this second panel entitled Whistleblowing and Disinformation, Exploring the Legal Challenges will be just as interesting as the first one and the other and the preceding ones. Let me introduce the first panelist. I will introduce each panelist before they intervene in the panel. So the first panelist is Francesca Benatti. She is a professor, associate professor of comparative law. She has been teaching at the University of Padova School of Law until very recently. Now she holds the same position at the Catholic University of Milan, at the School of Law of the Catholic University of Milan. And she is a dear colleague and friend. We're already missing her in the University of Padova. She's still a member of the board of the PhD School of International Private and Labor Law at the University of Padova, and she also serves as a member of the College of the Doctorate Program of Persona and Mercato in the Milan Catholic University. Her main areas of interest are contract law, tort law, property law, Chinese law, business ethics, and arbitration. She authored 3 monographs and several papers in different areas of comparative law. She taught extensively in many universities around the world, including Brazil. The floor is yours. The title of your speech today is The Whistleblowing Dilemma Between Ethics and Law. The floor is yours. Francesca, thank you for coming here today.
Thank you, Maurizio, for your kind words. I miss you too. And I want to thank the organizers for having me here. It is a great pleasure and an honor to be here to participate in this wonderful project. Whistleblowing from a civil law perspective is recent, not only for legal reasons, but above all for moral reasons. Many reasons were highlighted by other speakers. It was in fact considered problematic or questionable. One potential reason is that the relationship between morality and whistleblowing, as was stressed by legal scholars, involves a complex trade-off between different orders regarding concerns or moral values. Specifically, whistleblowers must decide whether to prioritize concerns for their own group in the name of loyalty or extend consideration to people beyond their immediate group in the name of fairness or justice. The greater people's concern for loyalty, the less likely they were to blow the whistle. And as it was said, the greater people's concern for the well-being of the wider public, the more likely they were to blow the whistle. It is said also that in one of the reasons for the introduction of regulations to protect the whistleblower was in the United States or in other legal systems, the need to remedy the principle, still strongly rooted, of termination at will of the employment relationship, according to which the employee is subject to discharge at any time and for any reasons. In our system in Italy, regardless of recent regulation, the employee was already protected, at least partially, from retaliation by the employer, because according to a consolidated orientation of the Supreme Court, the reporting of wrongdoing by the employee is part of his right to criticize, and any dismissal to be placed in connection with the report must be considered an act of discrimination and therefore void. So the regulation of whistleblowing was initially left to codes of ethics, codes of conduct, but in light of the scandals and international pressure, it became difficult to leave the regulation of whistleblowing to code of ethics, also because of the uncertain legal nature of these codes in the system. However, when we try to regulate whistleblowing, both through legislation, but even through case law, we need to address a number of problems. The first one is the objectives of the regulation, because we can say that it is different to regulate whistleblowing from a shield protection or considering the benefits of whistleblowers for society. For example, a legal rationale based on the benefits of whistleblower for society may expand upon a mere protective framework destined to shield whistleblowers from retaliation and broaden the scope of the law in order to include incentives to encourage whistleblowing. Legal reasoning placing the focus on the balance between personal connection and duty of loyalty would reject such a conclusion and limit the application of whistleblowers to a protective aim. The first approach promotes a fundamental vision of whistleblower, while the second emphasizes the idea that whistleblower laws and regulation needs to be corrective. However, if we try to analyze from a comparative perspective these different conceptions of whistleblowers regulation, we discover that they are not exclusive. In fact, they are often complementary. Indeed, the legislators' intention in developing whistleblower laws may often be influenced by different considerations, depending on the sector or field of law, the gravity of the importance of whistleblower regulation. So we see a fluctuation between a protective intent and the desire to encourage whistleblowing. As a consequence, even courts might interpret those regulations in different ways, stressing different elements, considering different perspectives. Another problem, a further problematic profile, may concern the activities that can be the object of whistleblowing. It seems to me that there is a great problem in that. The whistleblowing many times refer to revealing something fake, revealing disinformation, disclosing disinformation, disclosing what is fake. But many times the problem is that we don't really know what is fake, or let's consider, for example, the case of an employee of a communication company, of a social media, that disclosed the use of fake news. In such cases, it is difficult, in my opinion, because many times, how many fake news have turned out to be true? Many. So there is not always a black and white situation. Many times the problem is a gray situation. So, for example, many cases are clear. For example, think of an employee who learns with certainty of the use by the company of forced labor, or that the company polluted the environment. But many other cases are not that clear. So we can say that many times the regulation depends on the wrongdoing, if it is just an immoral act or an illegal one. From a legal point of view, this is important, even because even if the whistleblower is protected, if there has been no malice or gross negligence, many times he might be worried that he of creating something huge for nothing. So we need a balancing between the need to increase reporting and the need to prevent the legislation from becoming a free pass for the whistleblower. This is why the European directive is a very important point for overcoming the fragmentation in the discipline of the different states member, and often even within the different states. Italy has many laws about whistleblowing, and also for correcting a European case law that at times seem very unsatisfactory. For example, if the Bermejo case was a success because it establishes the criteria to identify the good faith of the employee in whistleblowing, and they are the seriousness of the violation, the authenticity of the information, the methods of communication. It is important that the first communication is private, and according to many, even the motives of the employee. And these criteria are the same. We can draw a parallel with the criteria of the European Court of Human Rights that established 6 criteria. For example, the public interest of the reported information, the reporting channel used, the authenticity of the information, the good faith of the individual, the damage suffered by the employer, and the severity of the sanction imposed upon the individual who reported. Other cases, such as McCoy, were hugely disappointing and raised great conflicts and great controversy over the lack of protection given to whistleblowers. So even if we might criticize the directive, and there are critics regarding the limited scope of its application, the directive does not cover every sector of law. For example, it is regrettable that the directive does not require the creation of a centralized European authority that could monitor whistleblower reports. On the other hand, we can say that the text agreed is a key step in establishing a minimum threshold for the protection of whistleblower in the European Union. In many European unions where the current protection is sufficient or non-existent, the directive will have significant consequences. In others, it will standardize the applicable rules by imposing a higher standard than that developed by the states member with legislation on the matter. So it is a first step, I think. It is an important first step, but it is a good one. And it is a way to raise awareness about whistleblowing, even in civil law countries where the subject is not considered so important as it is, for example, in the United States. So thank you very much.
Thank you, Francesca, for your effective presentation and for respecting your time assignment. So I think you were able to give a list, an overview of what is the European perspective and the status of the current legislation or a lack of legislation or uniform legislation within the European Union. And so much is still left to the member states, legislators or courts but the European Court of Justice will, I'm sure, will very soon step in using the new directive that should have been implemented in all member states by the end of last year. Italy, for example, is still waiting for an implementation, so is violating EU law because of this delay. But many other member states are on the same footing, and so we are looking forward to this implementation in order to start working on advancing the protection of whistleblowers. And also, as you pointed out, to balance the many interests at stake when we talk about whistleblowing. Let me introduce our second esteemed panelist of this second panel of day 2 of the international conference. And that would be Katherine Eban. I don't see her on the screen yet, but please let me say a few words in order to introduce her. Katherine Eban is an American investigative journalist and author. Her investigative work has focused on public health and homeland security issues. She's a contributor to Fortune magazine and Vanity Fair, and she writes for a variety of other national magazines. Her latest book, a New York Times bestseller, Bottle of Lies, the inside story of the generic drug boom, is an investigation to the generic drug industry and exposes one of the most memorable frauds perpetuated by a giant pharmaceutical company and the subsequent risks for patients' health in the US and abroad. Katherine, welcome to our panel. The floor is yours. You will be presenting Dinesh Thakur, The Perilous Journey of a Whistleblower. Thank you.
Thank you very much for having me. It's a pleasure to be here and to join so many of you who have worked so hard on this issue. I am not an academician. I don't work on policy, but what I do is tell stories and expose wrongdoing. And my work, in the course of my work over more than 2 decades, I have told the stories of numerous whistleblowers. What I'm going to do is share my screen, and I have a few slides that will be under discussion if I can find them. Where are they? Hold on 1 second. I don't, just 1 moment. Hold on. Let's try this again. Okay. Okay, can you all see my slides?
Yes, we can. Thank you.
Okay, good. So let me just start from the beginning. So I'm going to talk today about my book, Bottle of Lies, which came out in 2019. The reporting for this book took a decade of reporting on 4 continents, interviews with over 240 people, including numerous whistleblowers, over 20,000 pages of internal FDA documents, which were leaked to me through sources, thousands of pages of internal corporate records from a number of generic drug companies, and 16 Freedom of Information requests that I filed. So the main character, the main story that first let me talk about how I got into the reporting for this. So in 2008, I got a phone call from an NPR radio show host named Joe Graydon, who said he was being flooded with patient complaints about generic drugs, that if patients were switched from a brand to a generic or between generics, they became unstable, they had side effects. And he posed a question to me: what is wrong with the drugs? So I began to investigate. I studied the requirements for getting a generic drug approved in the United States and the FDA standards, which had a lot of loopholes. But as I reported, I heard more about a company called Ranbaxy. It was India's largest generic drug company, and at the time, it was the fastest growing generic company in the US. The CEO at the time was the grandson of the company's founder, Malvinder Singh, who was known in the Indian business press as the Pharaoh of Pharma. And this interview with him in 2004 was sort of typical of his bravado, where he talked about how aggressive the company was and how it took risks, but he never spelled any of that out publicly. But I began to hear rumors that there was some sort of Justice Department investigation into Ranbaxy's conduct. So as I dug in, I sort of studied how you make a generic drug. And the drug is supposed to go through all of these stages of development where you figure out what molecule you're going to use to make a generic. You make small batches in the laboratory. You scale up the batches to exhibit batches. You do bioequivalence testing, stability testing. Finally, you manufacture large commercial doses and you file an abbreviated new drug application with the FDA. And all of this has a certain amount of time baked into it. It takes months and months and months to develop and get a generic drug approved. As I began to scrutinize Ranbaxy, I learned a little bit more about how aggressive the company was. And these are some slides from internal PowerPoints from the company where they talked about their vision, their corporate vision, which had to do with profits. So they had a vision to get to 5 billion in revenue by 2012, and basically to realize those profits in the US market. The Justice Department's investigation, I learned, was focused on the question of whether Ranbaxy had tried to accelerate its timeline for development through data fraud. So was it taking these earlier, easier to control smaller laboratory batches and manipulating the data so that in their applications to the FDA, it looked like they were making these big, hard to control commercial batches. And that would make the data look much better than it actually was. And in fact, the FDA reviewed data. It didn't test the drugs before it made approvals. It took me months and months, but I found out that the head of research and development at the company had begun to suspect that the company's data was fake. And he tasked his subordinate, who I'll talk about in a moment, with investigating the data inside the company. And that subordinate delved into the company's international regulatory findings and discovered that more than 200 products in more than 40 countries had been filed with fake data. So this was nothing short of a global crime. What it meant is that patients around the world were getting Ranbaxy drugs that had not been tested properly and that were made with fake data. This is a smoking gun document alleging this, which was presented to the board of directors in 2005. And it proposed that the company come clean. Instead, the board of directors voted to destroy the PowerPoint document and to destroy the computer on which the PowerPoint was made. This is the fellow, Dinesh Thakur, who did the internal investigation into Ranbaxy data. And a couple of months after that PowerPoint was shown to the board of directors, the company's executives planted porn on his company computer, came in and did an investigation and forced him out of the company. So he could not stop thinking about the risk to patients all over the world. He wrote to regulators in numerous countries, almost all of whom ignored him. And then finally in 2005, he wrote this email to the commissioner of the US FDA, Lester Crawford, where he said, "I finally write to you to plead with you to put a stop to this crime." And that is what propelled the FDA into what became an 8-year investigation of Ranbaxy. Now, I should say that at this time, Dinesh Thakur was based in India. There are no legal protections for whistleblowers in India. He was absolutely risking his life to bring this forward. So in 2013, I published this story in Fortune magazine, which was all about Dinesh Thakur and what had happened inside Ranbaxy. But of course, I was left with the question, Was Ranbaxy just an outlier or the tip of the iceberg? I spent the next 5 years investigating the generic drug industry and found that, in fact, Ranbaxy was representative of what was going on in the industry, that there were numerous companies that were making drugs without using good manufacturing practices, but selling them into GMP markets for profit, undercutting their own products, using hidden laboratories to secretly test their drugs and then alter the parameters of the official tests, misrepresenting drug quality through fake data and submitting that data to regulators to gain market approval. This is a picture of a hidden laboratory inside of a manufacturing plant in India, where the company called it a decommissioned lab, but actually inside they were secretly doing tests and figuring out how to game the official tests to make the data look good. These are some images of drugs that are being made in non-GMP facilities in India. In this one, you can see a snake inside the manufacturing plant. This is an image of a live bug entombed in a blood pressure capsule made by Dr. Reddy's in India. And it was a lady in New Jersey who ended up getting this capsule. One of the most troubling things, and it is the thing that led Dinesh Thakur to blow the whistle directly, is that a number of generic drug companies basically alter the quality of their drug depending on the market that they're selling into. So if they're selling into highly regulated market like US, that'll be one quality. But if they're making, say, HIV drugs for Africa and it's a market where there's little regulation, they will send the lowest quality drugs. Here is a picture of what is supposed to be a sterile manufacturing plant making what are called active ingredients for the drugs. You can see bird droppings and a monkey here next to these sterile vats of active ingredient. In a conference call, an American scientist at Ranbaxy raised concerns about the quality of HIV drugs for Africa, at which the Ranbaxy medical director told her, "Who cares? It's just blacks dying." And even though this reflects, terrible racism, in fact, I believe it was really largely the profit motives that led them to undercut their own products for profit, so long as they were not going to get caught. And if it were not for the courage of Dinesh Thakur, they would have gotten caught. They wouldn't have gotten caught, excuse me. There was a successful, ultimately a successful key TAM case and settlement in which he got over $40 million from the US government for his participation in blowing the whistle. But again, anybody who is doing that from India has no legal protections at all. So thank you for listening.
Well, really impressive what we've been hearing in the last 12 minutes. Thank you to Miss Katherine Eban for her wonderful presentation and for her investigative job that she did over many years. And I definitely am astonished by the story you investigated and the facts that you found and the liabilities lying behind all this. I think we should be all concerned about the lack of uniform rules around the world, throughout the world, regulating not only, of course, the pharmaceutical sectors, but also the whistleblowing activities. We need probably, this is a further example We had many already throughout this project, but this is an additional one that we need more rules and a more uniform. There is a call for uniform rules around the world in order to foster and protect adequately the whistleblowers. So thank you again for your outstanding presentation. And let me introduce our last panelist. And again, as a colleague and dear friend at the University of Padova School of Law, associate professor of labor law, Silvia Bertocco. She is she teaches labor law, of course, European labor law, and she's also the chair of our master degree in international business law, and she's also deputy director of our private and critique of law department. She sits on the board of our PhD School of Labor Law, International Law, and Private Law. She authored many publications on labor law and protection in the workplace, which is one of her field of research. And today she will be presenting on whistleblowing in the workplace, the Italian case. The floor is yours. Thank you, Silvia.
Thank you very much, Maurizio. Good afternoon, everybody. I would like to thank, first of all, Professor Grasso and Stephen Holden and all the organizers for the invitation to this important international conference, and many congratulations for the interesting project. I think it's really useful to have a comparative approach to the whistleblower phenomenon. In the few minutes I have, I want to give you some highlights about the Italian regulation regarding the protection of whistleblowers in both public and private employment relationship. As you well know, whistleblower is a person who reports breaches of a specific legislation, such as European Union law, national law, or particular legal matters. In Italy, for example, we apply the protection also when whistleblowing is referred to social corporate liability, health and safety regulation, or data protection regulation in the workplace. But before analyzing our national legislation, I would remember, as underlined yesterday by lawyer Samantha Feinstein, and right now by Professor Francesca Benatti, that the European Union introduced a particular regulation in 2019 with the directive number 1937 on the protection of persons who report breaches of union law. The aim of the directive is to provide balanced and effective whistleblowers protection by introducing common minimum standard rules. The deadline to transpose the directive has expired last December, and Italy has still not implemented the union rules, but we have a draft that our parliament should discuss in these days. Nevertheless, many aspects of the European principles are already adopted in Italy. So I would like to share a few considerations on this common legal background. First of all, the idea that persons who report information about threats to the public interest obtained in the context of their work-related activities make use of their right to freedom of expression, enshrined in Article 10 of the Convention for the Protection of Human Rights and Fundamental Freedoms, but also in Article 1 and 8 of our fundamental labor regulation called the Statute of Workers, that is the law number 300 published in 1970. Moreover, whistleblowers need specific legal protection where they acquire the information they report through their work-related activities, and therefore run the risk of work-related retaliation. For instance, for breaching the duty of confidentiality or loyalty. The underlying reason for providing such persons with protection is their position of economic vulnerability. In fact, protection should firstly apply to persons having the status of workers within the meaning of Article 45 of the European Treaty. But protection should also be granted to workers in non-standard employment relationships, including part-time workers and fixed-term contract workers, as well as persons with a contract of employment with a temporary agency, volunteers and trainees. So the concept of worker also includes public servants, public service employees, as well as any other persons working in the public sector. Protection should also extend to categories of natural persons who, whilst not being workers within the meaning of Article 45, can play a key role in exposing breaches of union or national law, and may find themselves in a position of economic vulnerability in the context of their work-related activities. Such categories of persons include self-employed persons providing services, freelance workers, contractors, subcontractors, and suppliers are typically subject to retaliation, which can take the form, for instance, of early termination or cancellation of a contract for services, a license or permit, loss of business, loss of income, intimidation or harassment, blacklisting or business boycotting, or damage to their reputation. Shareholders and persons in managerial bodies can also suffer retaliation, for instance, in financial terms or in the form of intimidation or harassment, blacklisting, or damage to their reputation. Protection should also be granted to persons whose work-based relationship has ended, and candidates for employment or persons seeking to provide services to an organization who acquire information or breaches during the recruitment process or another pre-contractual negotiation stage, and who could suffer retaliation, for instance, in the form of negative employment references. Protection, finally, should be provided against retaliatory measures taken not only directly vis-à-vis reporting persons themselves, but also those that can be taken indirectly, including vis-à-vis facilitators, colleagues, or relatives of the reporting person, who are also in a work-related connection with the reporting person's employer or customer or recipient of services. Resuming, the key points of the legislation are four. First one, the protection applies to specific breaches of union law or national law. For example, tax fraud, laundering money, torts in the public procurement area, product safety and compliance, protection of the environment, transport safety. Second, the protection is granted not only to reporting persons having the status of a worker, including civil servants, but also to persons having self-employed status, shareholders, and persons belonging to the administrative, management, or supervisory body of an undertaking, including non-executive members, as well as volunteers and paid or unpaid trainees. Third, prohibition of any form of retaliation and discrimination against whistleblowers, such as dismissal, demotion, change position, change of place of work, reduction in wages, change in working hours, negative reference, disciplinary measures, intimidation, harassment, and mobbing. Fourth, reporting persons can choose between internal or external reporting channel that private or public companies must create. In any case, they have the duty of confidentiality and the protection for their personal data in accordance with the EU regulation GDPR. As I said before, Italian legislation has already introduced this kind of similar general protection framework for whistleblowers in the workplace, starting from the legal notion of whistleblowers that includes public or private employee who reports breaches of national law against corruption, fraud, money laundering, public procurement, protection of health and safety in the workplace, protection of personal data. I'm referring to the law number 179, 2017, introducing specific regulation of the whistleblowing phenomenon in the workplace, both for the public and the private sector. This law, amending the Public Employment Act, Article 54 bis of the Legislative Decree 165, 2001, and Article 6 of the Legislative Decree 231, 2001, that regulates private companies' liability. The law focuses on prevention of corruption and illegal activities put in place from public administration or private companies. For this reason, unfortunately, the protection for whistleblowers in Italy doesn't apply to harm or violation directly related to the employment relationship, with exceptions for health and safety regulation and data protection regulation. Protection is applied on the basis of certain legal conditions. First, whistleblower should be an employee or other categories of persons specific mentioned by the law, such as self-employed worker or trainee. Reporting should concern illegal activities of public bodies or private companies, which include criminal, administrative, and civil offenses to the public interest or to the labor contract, as well as irregularities in the management or organization of public activity. Whistleblower must acquire the information he reports through his work-related activities. And finally, each public body or private company should have an internal supervisor and should create a specific procedure for receiving and following up the reporting. The protection system for whistleblower is basically based on prohibition of retaliation. First of all, whistleblower can choose between reporting through internal or external channels, which means to address the reporting directly to the National Anti-Corruption Supervisor Authority or to judicial authority. Second, is granted the protection of the identity of the reporting person and of his personal data in accordance with the European regulation. Third, are forbidden direct and indirect retaliations such as discrimination, dismissal, demotion, change position, change of place of work, reduction in wages, change in working hours, negative reference, disciplinary measures, intimidation, harassment, and mobbing. And finally, in legal proceeding for breach of copyright, breach of secrecy, breach of data protection rules, disclosure of trade secrets, Whistleblowers shall not incur liability as a result of reports or public disclosure if they had reasonable grounds to believe that the reporting was necessary for revealing this breach.
Silvia,
So,
I will ask you
very
to
much.
conclude, please.
Yeah.
Oh, okay. Perfect.
Thank you very much.
So it was fortunate that my intervention was right at the end of your wonderful and thoughtful presentation. Very detailed, very technical. I think I think we learned a lot from things that I didn't know as a business law scholar. I think your presentation might be useful for also for the audience, not only to learn what is the legislation in Italy, but also to in a way to provoke a comparison between the different legislations currently implemented in different areas of the world. As I said at the end of the second presentation, we need a uniformity. Probably one of the most one of what we need the most on whistleblowing sector is a uniformity. But before we get uniformity in the legal field, we first need to know each other's legislation. So comparative analysis and comparative approach might be the first step for maybe for another project. Costantino maybe and the NATO will like to foster and to organize, and of course University of Padova will be happy to help and contribute again. So I think this is the takeaways is that we need to compare different legal systems and to come out with maybe some common grounds to protect whistleblowers in a more effective way than it is currently. I think we have still few minutes for questions. So I will ask all the audience to raise their hands if they have questions. But meanwhile, I will also ask all the panelists, not only the panelists, the current panelists, but all the panelists, today's panelists, if they have questions. And I already see there is one from Stephen Olden. Whom I would like to thank again for this great organization of all the project. So Stephen, if you want to ask your question, please, the floor is yours.
Thank you very much, and thanks for some extremely informative and very interesting and enlightening talks, certainly. One of the recurring messages that we've been receiving from not so much whistleblowers themselves, but from the organizations who engage in forms and means of retaliation, is that the simple act of criminality or sanction itself is not a big enough disincentive to not engage within retaliatory conduct. So that is to say, it's more important for them to send the message, if you step out of line, we will come for you. And that is regardless of the implementation of significant fines. It's regardless of things like deferred prosecution agreements. And what we've seen is that they are, in practice, quite ineffective in curbing powerful actors' behaviours, especially when they have deep pockets. And I think with regards to the law and how well it can be drafted, the law can be the most best drafted law that we've ever seen. However, it counts for naught unless it's meaningful and effective. So I think what my question really is in light of this, what reforms do we think we could meaningfully take in order to affect and tip that balance, and in order to kind of really disincentivize powerful actors from engaging in retaliation? What sanctions could we bring forward that are meaningful, as the current ones, unfortunately, aren't?
Sorry. Thank you for your questions, which is a couple of questions together. Maybe I don't know whether Silvia or Katherine or Francesca would like to answer. Basically, what are the provisions and the sanctions that might be useful, if I may summarize your point, your question, might be useful to be implemented on a uniform basis in order to make whistleblowing more effective. I'm sorry if I summarize your question.
No. It's that's perfect. Yeah, it's a much more succinct, slightly more succinct way than I have.
I can give you briefly my opinion if you want. I mean, I think it's a culture problem. So first of all, to train all the company and to train all the people to change the mind, our mentality, our culture in facing the whistleblowing phenomenon. And on the other hand, the sanction, the worst sanction for company, for me, it's always the bad publicity. So use the media, use the social media to expose the behavior of the company.
Public blame. I agree.
Yeah,
Maybe Katherine wants to add something. Sorry.
yeah, I would just say that my experience in reporting on the generic drug industry, because they are generic, so they don't sell into markets based on a name brand per se, they are less sensitive to public shame. What they really care about are profits and ability to enter markets. So for example, one of the reasons that they go to great lengths to fake all this regulatory data is so that the FDA or other regulators don't come in and sanction them and close off entry to markets. That's what they care about, is access to markets. And so, you know, if you could figure out how to restrict access to markets based on their treatment of whistleblowers, that would be meaningful, I believe.
Yes. Thank you, Katherine, for your insightful thoughts. And I think there is another question from the audience, and I welcome Hugh Wilkins to ask his question to Professor Francesca to step in with one final question.
Thank you.
Ciao,
Thank you,
Donato.
Maurizio.
Welcome.
It's not a question, it's just a point, because sometimes this balance is really not clear. For example, if we think to the recent case LexLeak, of course, where there was a disclosure of tax documents related to an important case of tax avoidance, the European Court of Human Rights, we were talking about this, decided at the beginning to say that conviction, also in the case of bona fide, was perfectly fine. But now we know that the Crown Chamber is changing idea about this. And there was a hearing recently in February 2022. I think that the point of the balance is very delicate, but if there is a crime, is there a public interest to know this crime? Is there a public interest to know crime that affect many people? Because it's often we talk about multinational. Of course, there is another issue about the connection with misinformation, disinformation, because this is also another point. So just to have a connection with topic today. Just this is my idea, my opinion. The balance is very complicated, but at the same time, the interest to know that a company is committing a crime, and considering that there are all the conditions to know it, I think anyone should disclose. We don't need too much channels, especially when there is a limit within corporation. I know that anyone would like to protect corporation, but at this moment, the things should be changed. At least to increase responsibility. This is my little opinion. Of course, we have no time to go into details, but happy to share these different ideas. Thank you very much for your wonderful panel and wonderful presentation.
Thank you, Donato. I appreciate your you summarizing and pointing out a very important issue. Of course, I think we all agree that when whistling entails the commitment of or the perpetration of a crime, then the public interest should prevail always. I think we all agree on that. Probably the most delicate, striking the balance between interest to disclose and the legitimate interest of a business to keep information private, some business information private, is when a crime has not been committed, but still there is some fake news or some information or disinformation ongoing. That's probably and of course I think what emerged, and this is my very final comment, what emerged from this interesting panel is that we have a stakeholder society which involves many stakeholders, many constituencies in the public sector, in the health sector, in the private sector. So probably we need the different standards depending on where and what we are dealing with. So maybe one fits all. It's not. I don't know. I just a guess. It's not. It will not be an accurate standard for whistleblowing and protection and threshold. One last word. As a University of Padova representative, and just to tag on to the next panel, we are very proud that we have so many participants in the next panel, students participating to the poster competition, and just want to, on behalf of my colleagues, Francesca, Benatti, and Silvia Bertocco, would like to express our happiness and our proudness that so many students from Padova applied and also got satisfactory results. So that with these words, I just end the panel. I know we overextended the panel, but I hope it was worth for all the audience. And so I would like to thank again Costantino and Stephen and all the audience and all the panelists for participating to this panel.
Thank you so much, Maurizio, for chairing this so fascinating panel, and thank you to all the panelists. We have gone a bit over time, so I will say let's have just 5 minutes break, and in 5 minutes we can reconvene for the poster competition award ceremony.